So I think we were discussing difference between ownership and possession, right?
Yes,
Class.
today, yeah, to discuss, yeah. Yesterday, covered duties.
Yes. So today we
AIBE.
have kinds of ownership. So when we talk about ownership, again, there are different types of ownerships that we get to see. Some of these types again might be repetitive as well. So different kinds of ownership. There are many kinds of ownership. Some are corporal, some are incorporal ownership, full ownership, co-ownership, legal and equitable, vested and contingent, trust and beneficial ownership, co-ownership, joint ownership, absolute and limited ownership. All these different classifications we get to see. First classifications that we have is corporal and incorporal ownership. A corporal ownership is the ownership of material objects, and incorporeal ownership is the ownership of a right. So ownership of a house, a table, a machine is corporal ownership. Corporal as in something that we can touch, see, or feel. If it's a house, if it's a car, a pen, a laptop, it is something that is having physical existence. We can touch, see, feel it. So if there is a laptop, the owner of that laptop is having corporal ownership because the object is something that we can touch, see, or feel.
Tangible.
Yeah, tangible, correct, like tangible. But in case of incorporeal, it is right is there, but it's something which we can't see, we can't touch, or we can't feel. Like ownership of a copyright, a patent, trademark is incorporeal ownership. You might say that, okay, in case of copyright, trademark, etc., also we will have some documents or the item would be there, right? If it's a book on which copyright exists, the book is there. But as such, it's a book, but your right is different. That right you cannot touch, see, or feel. Okay, because if someone else is buying the book, that person is owner of the book. But what right you have? You are not like owner, but you have a copyright on the book or what is written there. So that right is something which we cannot touch, see, or feel. So it is incorporeal ownership. The difference between corporeal and incorporeal ownership is connected with distinction between the corporeal and incorporeal things, something that we can touch, see, and feel, and something which we cannot. Incorporeal ownership is described as ownership over tangible things, like you said, tangible things, something which we can see, feel, touch. Corporeal things are those which can be perceived, felt by the senses, and which are intangible. Incorporeal ownership includes ownership over intellectual objects or encumbrances. Might be you have someone has borrowed 10,000 rupees from you. Now you have a right to get back that amount. That is also some right which you have the right, but maybe you cannot touch, see, or feel. So there are many rights which we see. Better example is intellectual property rights which exist, and there are so many different kinds as well for that. Okay, second classification is trust and beneficial ownership. So we already know there are different trusts which are being established for a lot of different purposes, right? So this is something similar to that. What happens in case of a trust? So trust and beneficial ownership. Trust ownership is an instance of duplicate ownership. Trust property is that which is owned by two persons at the same time. The relation between the two owners is such that one of them is under an obligation to use his ownership for the benefit of other. The ownership is called beneficial ownership. The ownership of a trust is nominal and not real, but in the eyes of law, the trustee represents his beneficiaries. In a trust, the relationship between the two owners is such that one of them is under an obligation to use his ownership for the benefit of others. who is holding the ownership, that is trustee, for whose benefit it is taken, that is the beneficiary. So just like how in case of a trust it happens, like in case there is a trust for maybe welfare of children, they have opened a library, they have opened a school where they are providing free education to kids. In that case, there might be some trustees, 3-4 people managing the library, but they are as such not using it for their own benefit. Their main purpose is that children should get benefited out of it. So even though those trustees are having a lot of powers to take decisions, etc., in relation to the library or the school, it is in consideration to benefit of beneficiaries, right? They need to keep this thing in their mind that whatever action we are taking, it should benefit these children. So their ownership would be called as trust ownership, even though on the face of it, they are owners. They cannot use the library for their own purpose. They need to use it for benefit of those children.
Okay.
But when we talk about the children, they can come there, they can use the books, they can get free education and all of that. They are the ultimate beneficiaries. So this is trust and beneficial ownership. Sometimes you might also get that a child is owner of something, but maybe child might not be able to manage his own properties or belongings. There again, the guardian might be taking care of the property on behalf of the child. So guardian would not be using the property, but guardian will be taking care of the property for the minor, right? So in that case, we can say minor is a beneficial ownership and guardian is having trust ownership. Okay.
Yes.
Next one is legal and equitable ownership. Legal ownership is that which has its origin in the rules of common law, and equitable ownership is that which proceeds from the rules of equity. In many cases, equity recognizes ownership where law does not recognize ownership owing to some legal defect. Legal rights may be enforced in rem, but equitable rights are enforced in personam as equity acts in personam. One person may be the legal owner and another person the equitable owner of the same thing or right at the same time. Equitable ownership of a legal right is different from ownership of an equitable right. Ownership of an equitable mortgage is different from equitable ownership of a legal mortgage. There is no distinction between legal and equitable estates in India. Under Indian Trust Act, the trustees is a legal owner of the trust property and the beneficiary has no direct interest in the trust property itself. However, he has a right against the trustee to compel them to carry out provisions of the trust. Now, what is legal and equitable ownership? Legal as in something which law recognizes. Okay, and equitable is something which there is a concept called justice, equity, and good conscience. Like law might have written something, but considering the situation and everything, what should happen in a given condition, right? That is called as equity. Like I will give you an example to make it simple.
Yes.
There was a real life case. Okay, what happened there is, otherwise you must be knowing that in order to enter into a contract, we should be a major person, right?
Yes.
Major person, which means we should be 18 plus years.
18 years.
Otherwise, the contract itself is not valid, right? Now, there was a real life case where what happened is there was a minor. He was below 18 years of age, and this minor was owner of a property. But because he was minor, his mother was taking care of the property. Okay, his mother was taking care of the property. Now, what this minor did is he went to a person. Okay, minor went to a person and he said, I'm a major person. Okay, minor misrepresented his age. He said, I'm a major person. I'm above 18 years. I have this property. Would you be interested to buy this property or not? The other person said, okay, fine, I can buy this property. So for some amount, they negotiated the price and everything, and they fixed the price also. Okay, just take an example. It was 20,000 rupees. They agreed. And this person said, okay, fine, 10,000 I'm paying you right now. Remaining 10,000 I'm making a promise. I will pay you after 1 month's time. He took a written promise also for the remaining amount. After this entire thing happened, right? After that, this mother came to know. Mother came to know that there was this entire transaction which has happened. So mother wrote back to this person. Mother wrote a letter to this person and said that my son is a minor and he is owner of the property. So your contract is not valid. You cancel out this contract. The person said, okay, fine, I can cancel out this contract. You return this 10,000 rupees which he has taken. But they were not agreeing. They were not returning this 10,000 also. And they said, we are not giving you possession of property also because he is a minor. Legally, he is not bound to perform the contract. Okay, so in that case, court said that yes, when we go by law, person needs to be above 18 years. Otherwise, contract is not binding on them. But just because there is a provision like that, we cannot allow the minor to be taking advantages, that he will misrepresent his age, enter into contract. After taking benefit, he will say, I'm a minor, I'm not bound. That is very bad, right? So in that case, court said that even though this is a rule, we are not asking the minor that you give possession of property, but yes, you need to return this 10,000 rupees because you misrepresented your age. You made this person enter into a contract. You cannot take benefits just like that. This is not fair. Okay, what we say is not fair. That is only nothing but equity. Court also sometimes feel that this will not be fair if we strictly go by the law, right? So there are certain things which are recognized in equity. So equitable ownership is something which law would recognize. It might not be as such written, like this 10,000 rupees, right? Who is having equitable ownership? This person is having, because he was misrepresented by the minor. Okay, is it clear equitable ownership?
Clear. This is High Court judgment or?
This is Supreme Court judgment, I guess. I have that case also. I think some Lahore High Court judgment, I guess, this before independence only.
Yeah, and Mohari BV case judgment is against.
Yeah, Mohari BV is against. I think this was Khangul versus Lakha Singh. Mohari BV and this one, they both are like completely opposite judgments.
That is also Supreme Court, Mohari BV.
Mohari BV, yeah, I guess Supreme Court. And Khangul is, I think, Lahore High Court or something like that. Okay, so this is what is equitable. Equitable as in
sometimes judgment may come in favor of the mother.
Not mother, in favor of minor. It came in that Mohari BV
because
case.
Contract is invalid, prima facie. Buyer has to ensure that he has attained 18 years of age.
Yes. But in this case, because he misrepresented, right, it was minor's fault. So courts felt that it's not fair that we simply allow him to take the benefits. So court recognized this, right? So that is nothing but equitable ownership. Court considers equity rather than what is written in the law. Okay, so legal ownership, something which is written properly in law.
This is clear example for equitable ownership.
Yeah, equitable ownership. And legal ownership as in legal ownership. You have bought a property, property is in your name, documents are there. Legal ownership. Everything is fair over there. Okay, another classification we have is vested and contingent ownership. Do you remember what is vested and contingent? I think for rights also we got it. Vested rights and contingent rights, if I'm not wrong.
Vested already transferred.
Yes. Contingent?
Without any ambiguity. Contingent subject to a happening of certain things, ownership may come.
Yes, correct. So vested is already, it's given already there. Contingent, it depends in future ownership might be transferred, might not be transferred also. So ownership may be vested or contingent. It is vested ownership when the title of the owner is already perfect. Everything is perfect. Ownership is already given. But it is contingent ownership when the title of owner is not yet perfect. But yes, in the future, if the conditions are satisfied, then in such cases, it may become perfect.
Perfect.
In the case of vested ownership, ownership is absolute, but in contingent, it is conditional. It depends on fulfillment or non-fulfillment of some conditions. For instance, a testator may leave property to his wife for her life and on her death to A. If he is alive, he is then alive. But if A is dead, to B. So a person, before he dies, he might prepare a will and he may say that my wife will enjoy this property until her life. But once she dies, property will go to A. If A dies before my wife, in that case, it will go to B. So B's probability or A's probability, it all depends on conditions, right? Only if A is alive when his wife dies, he will be getting the property. Only if A dies, then only B would be getting. So everything is conditional. It would be decided in the future only. Here, A and B both are owners of the property in question, but their ownership is contingent. It depends on happening or non-happening of certain situations. It must, however, be stated that contingent ownership of a thing is something more than simple chance or possibility of becoming an owner. It is more than a mere spec acquisition. It's not that the person will get it only. There are a lot of things attached to it. Everything has to be fulfilled. Only in such a case, we can say that the person, there is a possibility that the person may get ownership of the property. Okay, so vested is already there. Contingent depends on fulfillment of certain conditions only.
Yes, but acquisition is what do?
So it is not that after the father dies, son will for sure and like get the property. It is not like that, but there is wife coming in between, there is A coming in, B coming in. So it is more than that. A lot many conditions will be satisfied. It's not that simply the testator dies and property comes to A or B. There are other things also coming over here. Okay, so contingent ownership is based upon mere possibility of future acquisition, but it is based on present existence of, depends on what would happen, right? Incoherent or incomplete title. Presently, title is not perfect. Conditions need to be satisfied. It will be decided in the future only.
Yes.
Okay, next is sole ownership and co-ownership. This is again very commonly used only. Right? Ordinarily, a right is owned by one person only at a time. However, duplicate ownership is as much possible as sole ownership. Sometimes we get to see, right? Joint account also people may open. Jointly a property people may buy. So joint ownership is also, or co-ownership is also equally popular. When ownership is vested in a single person, it is sole ownership. But when it is vested in two or more persons at the same time, it is co-ownership, of which co-ownership is a species. So joint, like sole ownership is like a whole, and within that there might be 2-3 owners also, which would be known as co-ownership. Like members of a partnership firm, they are not as such individually not owning the partnership property, but all of them are joint or co-owners of the partnership property. So when we talk,
all ownership is nothing but proprietorship.
Yeah, proprietorship, we can say. One person having entire rights, complete ownership.
Yes.
So co-owner is entitled to some rights, that is right to possession, right to property, right to dispose. All these different types of rights we are having. So co-ownership will be like joint ownership, sole ownership will be like the proprietorship which you have mentioned. Same ways we have absolute and limited ownership. Absolute owner is one in whom are vested all the rights. Absolutely, he is owner. There is no condition, no ifs and buts. He is absolute owner. Limited ownership, as in some limits might be there. So when all the rights of ownership, that is possession, enjoyment, disposal, are vested in a person without any restriction, it is called as absolute ownership. No restrictions apply. But when there are certain restrictions regarding user, duration, disposal, it is called as limited ownership. Mostly we say if a person has purchased the property and he has taken a loan, might be like LIC housing finance, the person has taken a loan. In such a case, what will happen? LIC will be keeping his property documents with it, that you cannot sell the property. You have taken loan from us. You cannot sell the property without our consent. That means the person is owner. No doubt about it. He is the owner of the property, but his ownership is limited ownership. He cannot dispose of the property without taking permission or consent of LIC housing finance. Right? So this is nothing but absolute and limited ownership. In absolute, maybe his loan was cleared. LIC returned all the documents and everything to him. Now he is absolute ownership. He can do whatever he wants with the property. Okay, so these are different types of ownership. Same ways we have for possession also, there are different types. And then we also have methods of acquiring possession, how possession can be taken. Okay, so we will continue this tomorrow then.
Yes, madam, then.
Hey, before we continue, I wanted to inform you about my live mentorship program for LLB students or law aspirants. Law subjects and law topics need detailed clarity. We get that with the help of cases, examples, and detailed explanation. It's definitely not possible to include everything in these short videos. If you find my videos easy to understand and you are looking for some professional help in preparing for your examination, you can join my live mentorship program. Here you will be getting exam tips, answer writing skills, detailed notes that you can refer for your examination, cases, examples, and in a very easy way topics will be explained. I have live classes going on for a lot of subjects as of now. To know more about it, you can drop me a message on this WhatsApp number. I'm also helping a lot of students in writing their assignments. If you need any such help or for any queries, any suggestions, you can drop me a message on this WhatsApp number. And now let's continue with our video.